All right. Hello, everybody. My name is Mackenzie Lemaire. I'm a graduating 3L student at LSU Law Center and a member of the East Baton Rouge Parish Prison Reform Coalition. I have here Judge Donald Johnson from the 19th Judicial District Court in Baton Rouge, and we're going to talk about how that court and how Judge Johnson himself is responding to COVID-19 in and out of the courtroom. So we'll open first, just generally. Judge Johnson, how you doing today? And
I'm very.
how in general, I guess, how's the court been?
Well, as you know, this coronavirus disease or virus is a respiratory illness, and it's heightened our concern and safety for ourselves, for our community, and for everyone that comes into the building. As you may know, we officially closed court on the afternoon of March the 17th. We had an emergency meeting that day, or the day before and the day before, and we made a decision that it was no longer feasible to operate in the current environment where we allowed access to the facility on a regular basis, where we allowed access to the public on a regular basis, where we allowed access to the building by visitors, by litigants, by attorneys, and by staff support, security, and anyone from the public. We decided to make a decision based upon paramount conditions that were not doable to function on a regular basis. We realized that when we made that decision that we had to be open for essential services, and the word has become essential for essential employees and essential services. So we right now we're going on our fifth week of closed access or limited access. We're not fully closed. We operate on a very limited basis. That is, the clerk of court is open daily. Our clerk office is open. I'm in the building now. That office opens every day at 8 a.m., the clerk of court, and it closes at noon. So we are allowing access to file pleadings, to petition the court, to gain access to the court by way of filing pleadings and notices with the clerk of court. So this is going on our fifth week of remote. We're operating right now. We've shifted to a remote type of system where most of us are attempting to work from our homes and abide by the shelter in or the stay at home policy. At the same time, we are addressing as quickly as we can matters of extreme emergency or emergencies, as well as matters pertaining to public safety and issues like that. So that's the framework that we have been working within. We've also shifted very quickly to the use of technology, remote technology. And that's a tremendous undertaking for us. We're used to having a lot of paper. Most of us, we're used to working in the building, in the facility. Well, we've been able to largely transition with equipment purchases, with accommodations of technology usage, and with reductions in the laws that apply to conducting proceedings in court hearings in person. There's been a relaxation in those rules. Also, there's been some relaxation in making personal appearances and swearing out affidavits and things like that. We are able to do a lot of that with the use of technology. And so we're accommodating to the extent that we can. That's a general approach. On the one hand, we are doing marginally well with access. On the other hand, we're getting a lot of requests. We're getting a lot of complaints from the public about access, about the ability to find us officers and get hearings conducted as quickly as needed. So we are addressing that as we can. The judges are being available, and we have a system set up where you can get access to a judge. So that's the framework. I'll let you ask me any other specific questions, but we are providing meaningful support to the public. At the same time, we're trying to be very, very accessible so that we can provide reasonable access and assistance to the public in this pandemic season.
Okay. All right. From what it sounds like, the general approach seems to be similar to what at least I've seen other courts doing, which is moving to remote work and relying heavily on technology, which is not very familiar to most courtrooms. So I've actually got your explanation sort of raised two questions sort of immediately. And the first is, who has the court decided is essential? And if there's any sort of, I don't want to say reason to it, I don't want to negatively say reason to it, but how did you decide who is essential, who stays at the courthouse? That's the first question.
When the concept of an essential employee, and when that terminology was used, we did not have in a manual, in a book, in a process folder that says, okay, in a pandemic, these are essential employees. That does not exist. Mm-hmm. So what we had to do was to relate the concept of essential. We related that to the access that the Supreme Court sort of outlined for the various judges and courtrooms. Basically, we were to stay accessible for public emergencies, for individual emergencies. And that was left to somewhat of a determination of the category and the nature of the emergencies. And I'll give you some examples. We had to be open to do matters of, let's say, criminal defendant issues. So we must remain accessible to hearing matters related to bonds, hearing matters related to arraignments, hearing essential matters regarding the release of individuals who may have been in contact with the virus. We had to be on notice and be available for that type of matter from a criminal justice standpoint. On the civil side, the word essential related to issues of safety and protection. So the categories and examples from that would be persons that would need protection from abuse, persons that would need access to the court regarding children issues. So we decided to link the word essential to the nature of the category of the relief that was being sought. And there's no way to just give you a list of the examples. For example, if someone needed to perhaps get a temporary restraining order to prevent some conduct that might happen that was unable to be compensated for, then we would need to hear that type of matter. Right now, we are scheduling petitions for protective orders. They come in daily. We see those. We set those for hearing, or we grant temporary relief by way of a temporary restraining order. So we are hearing those matters. We are doing arraignments here. We are doing bond hearings. Most of that is remote. Some of it took place in the courtrooms. Initially, we exercised social distancing practices, but once we got up to remote status hearings, once we got the capacity to operate remotely, then we shifted to that operation. But we did not fully close. We generally operated from a standpoint of closing the building, but providing restricted access, limited access into the clerk's office, limited access into the courtrooms. And we generally decided to suspend in-person proceedings. So, but we will allow in-person proceeding in case it is an emergency, and in case we cannot do that remotely. It cannot be done remotely. And we're granting extension of the court deadlines, including deadlines to pay any fees or fines. We are not issuing warrants for failure to attend hearings. That's been, all hearings will be eventually reset. So the public that's concerned about missing a court date, that the court is basically closed for that. So you don't have to worry about a warrant or you don't have to worry about having adverse consequences flow because you're unable to come to court. And we're encouraging everybody. And in some instances, we are requiring the lawyers to engage in teleconferences with the court or video conferencing in lieu of public hearings. Now, we are concerned about the access to those hearings. We are concerned about public and media access to the hearings. That's an essential requirement of the Constitution. And we're trying to look into ways of making sure that the public and the media gain access to the hearings and the events that we do proceed with. But on the other hand, we're conflicted with our obligation of not recording and not putting court hearings in the media circuit. So we're trying to balance that conflicting rule. We have a rule that we're not to hold court proceedings and allow them to be recorded by the media. So that's not our rule, that's our ethical guideline. So we've got to balance that with the right of access. And we're working through that. Some of the other things that we've done in terms of on the traffic court, where I said for sure, we have not issued any new warrants. We're not going to issue any new warrants. The warrants that are outstanding, we're working through that on a daily basis. I've issued an order that for any person who's arrested for a traffic court ticket on a warrant, that they be automatically released without posting of any bail. They're just going to be given a new court date. So I'm doing that for traffic offenses. With respect to early jail release, that concept came up. What are the judges doing about persons who may be wanting to get out of jail early? Well, there's been some meetings with the criminal court judges. Those meetings were held between the DA's office and the public defender's office or the private attorney. So those cases are being handled one-on-one with the judge who's in charge of the case. And anybody out there who is in custody or in jail, or family who has a member in jail, they can avail their lawyer, or they can contact the district attorney's office, or if they have a public defender, reach out to a public defender and attempt to arrange a video conference or a telephone conference with the judge. The judges have informed me that they are available to listen, to consider any matter which comes up during this period. There are also instances where the court has issued many bond modifications. If you've been noticing and paying attention, the court has, on a daily basis, reduced bonds, suspended financial obligations, or reset obligations. So the court is being responsive, and I want the community to know that we didn't just close shop and go home. We are available and accessible, but you need to reach out to us. You need to make certain that you get a hold of a member of the court. We have a duty judge. We have a duty judge for civil court. We have a duty judge for criminal court, and that is on our webpage. And if you're out there and you're needing access, I strongly recommend you go to our webpage, get on that webpage and look down for the 19th Judicial District Court duty section. And if it's a civil matter, call the duty judge that's on duty. If it is a criminal matter, call the duty judge that is on duty. And if you're unable to reach them, where they're very busy, the duty judge is here today doing call out and arraignments and taking pleas. If you're unable to get that judge because that judge is working in court, then you are welcome to reach out to another judge on the court and make an application to have that judge to reach out to a fellow member of the bench and let them know you're trying to reach out to them.
Okay. Well, it's great that the judges are taking, it sounds like they're taking direct applications from the public to sort of be as accessible as possible during this time. So that's maybe something that could survive this this time of emergency and increased accessibility of the courts. I do want to, it's something that you mentioned just very, very briefly, but I do want to ask two final questions. So short, you mentioned the Supreme Court's guidance in how the 19th JDC has transformed its work over the past few weeks. Did the Chief Justice's guidance letter specifically have an impact on the decision making, and if so, to what extent? And that's just a brief answer, basically yes or no. And then I'll end with a sort of maybe a little bit of an academic question, but you mentioned there's significant constitutional balancing or competing interests at play with the transformation of the court. This switch to remote or telecommunication hearings, there's the issue of public access to those hearings. And there's also been issues that have been raised even before the pandemic about the nature of remote hearings, especially with call out, and basically the distance that physically puts between the defendant and the judge, and how that affects the judge's ability to make determinations about the person's character, about the person's well-being, their physical state. So are those considerations heightened, and how are you dealing with it, basically?
Okay, with the first part of your question, yes, the letter from the Supreme Court, and that there have been three, and I'm not certain if that's a fourth order, but there was 3 consecutive orders which from the Louisiana Supreme Court. Those orders came in, I believe, 1 or 2 days apart, and they were modifying and they were developing practices and policies for us to follow. They were clarifying issues of closure. The letters were directing, and the orders were directing us to be on alert status and be constantly in a mode of dynamic change. So we were put on heightened status to be ready to deal with the state of affairs that were going to come into our courtrooms. And because of those orders, we quickly gathered, and the Chief Judge here, Chief Judge Fields, we have met every week on Wednesday. As a matter of fact, before I joined you, I completed a 1-hour meeting of the judges of all members of the court to discuss issues and plan accordingly. So the judges meet once a week, and we do have conferences if need be before that, but we are regularly meeting once a week to discuss issues. The Chief Justice of the Supreme Court sent us a letter, particularly addressing the issue of persons in custody. I don't know if you were privileged to that letter, but there's a letter that I can make available to you from the Chief Justice that spoke to us about our responsibility to balance the concerns of the exposure to the COVID-19 virus, at the same time to protect public safety. So yes, we discussed the letter, we discussed the impact, and we are all exercising extreme caution to comply with the recommendations and the requests of the Supreme Court Chief Justice. On to your second, the latter part of your question, relating to the rights of individuals, the right of access, the right of transparency, and the right to the media and the public to see what we do. I'll say this, we would like to provide, we would like to certainly have you access what we're doing so that you can observe it and make sure that we're exercising good judgment, that we're neutral, and that our proceedings are respected, and that the defendants and litigants who come before us, that we are receiving them and we're evaluating them just as if they were standing before us in open court. That is a challenge. We're in a new world, though. And because of the requirements that we protect that individual from exposure, in other words, that we protect that person from getting exposed to the virus from a member of our staff, getting exposure from a member of the law enforcement team, getting exposure from anyone on our side. So we must protect that individual as well as protect ourselves. So we have a duality, or more than a duality, in terms of who we're concerned about. Our employees, also, that the people that handle the process, that do the actual paperwork or electronic work, that's a concern for them. And so we're balancing all of those concerns at the same time. We're trying to make sure that the individuals get before the court. It is a challenge for us to do character evaluations through electronic means. So that will require us to getting trained. In essence, all we need now is to get the essential training so that we will be able to look at the factors that we would utilize, that those red flags that we would want to know about if I'm conducting a virtual court setting, that I'm to undertake these extra measures. I'm to undertake an extra colloquy. I'm to ask additional questions. That's what is being required of us. And for example, we are participating on a regular basis. For example, today, I'll be on 3 or 4 webinars. And I'm on 3 or 4 webinars every day, looking and learning about this current state of affairs, how to adjudicate remotely, how to adjudicate in the age of COVID-19. And the National Center for State Courts, the National Judicial College, the Louisiana Judicial College, we're inundated with this new method of learning. And I would venture to say in the past 3 weeks, I've seen at least 16 different webinars about how judges and the courts are to operate with a new way of doing business. So it requires essential training, but I am sensitive to the need of character evaluations through remote settings.
Okay, and it sounds like that training is readily available for the judges.
It is. Now, what we do is some of us have memberships in organizations, and what we do is share that resource. For example, today, Judge Confessor sent me an email sharing a resource, but I left here about 9 last night, and I had already gotten on that website and made it accessible for myself. So we're sharing resources through our individual connections with organizations and affiliations. And it's a comprehensive, a collaborative approach, but we're all wanting to be on our best performance level during this season.
All right. Well, I think that's about the time I have you for. If you have any sort of closing remarks, anything that you'd like the public in general to know, now would be the time to sort of leave us with that, and then to go on to those webinars.
Very well, thank you. The pandemic has affected the entire criminal justice and civil justice system. Everybody is adjusting. I truly believe that everybody, particularly in the criminal justice system that I'm so connected to, I am pushing every day to make the access to the court as efficient and as effective as it can be. And if you find yourself in a situation where you're unable to reach a member of the court, I welcome you to give me a call. I will make certain that I put you in contact or relay your information to that juridical officer. So cheer up, and if you are still fearful or you do not have access, Judge Don Johnson, you may email me, and I will make certain that I forward your request on to the appropriate court. Thank you very much.
All right, and thank you for joining us. Have a great day.
Thank you very much. Bye-bye.